welcome back to the Huddle. Today I'm with Wallach Legal LLC founder Daniel Wallach. How are you today, Daniel?
Doing great, Kirk. Thanks for inviting me to join the pod.
Of course. And you took part in a panel yesterday discussing how prediction markets are kind of reshaping the definition of gambling. How is that being done? And, how did the panel go overall in your mind?
Well, I think the panel was more about how courts are reshaping what prediction markets are. The panel discussion went very well. It was a call to arms, really. I mean, the audience consisted of a lot of tribal officials, tribal leaders, state gaming regulators, and just people who are, sort of part of the resistance. I think prediction markets are the resistance. The incumbents were in the audience yesterday, and I think it was important that they heard an overview of what's happening in the courts, what strategies are working when states prevail, and they've prevailed so far in 13 out of 15 contested motions for preliminary injunction or temporary restraining order. So the states have swung the pendulum back in their favor, and I think it was important for a tribal audience to hear about some of the strategies and as well as the importance of what's going on in these court cases and how it impacts tribal gaming.
Absolutely. I was also wondering, as a gaming and sports attorney, how can you help tribes, state, or federal bodies better prepare for regulating prediction markets or find the path forward?
Well, I don't think there's any path forward for states and tribes with prediction markets except to win. Mm-hmm. This is sort of a zero-sum game. I don't believe that there's any room for compromise. It's not as if the prediction markets are gonna make a settlement offer where, okay, we'll allow ourselves to be regulated by the state. I think it's either all or nothing. And right now, I don't really see a middle ground. I think there's certain appetite maybe within among state regulators to have exchange wagering and to allow some form of prediction markets or event contracts. But I don't think it's a pond that that these federally so-called federally regulated companies want to play in. So this is all about separating the winners or the losers, and the courts are going to cut through all this and decide who's right about the issue. So for the tribes and the states, this is a battle for not only their sports gambling relevancy, but their casino gambling relevancy, because the next step, the next shoe to drop, once this becomes, if it becomes entrenched, is for casino contracts. Online casino games to be the next vertical of event contract that these companies try to introduce into the world of the CFTC. And when that happens, I think that could be devastating financially for tribes as well as for state, gaming ecosystems. So this isn't only about sports betting. It is about all forms of digital gaming being shoehorned into this thin premise of the CFTC categorizing all this as a swap. It's all BS, and it's a very flimsy premise. But in order to get that judicially recognized, someone has to take the step forward, bring these lawsuits, and fight the fight in the courts. And so far, states like Nevada, Massachusetts, Michigan, Maryland, New Jersey, roughly a dozen states have stepped up to the table. But the vast majority of states that have online sports betting and online casino and regular land-based casino, they're still on the outside looking in. So part of my role, I think, the role that I'm playing, the important part that I play in these kinds of conferences are to sort of rally the troops and explain what's at stake to the states and the tribes and what they can do going forward to try to make a difference.
And in your experience, how has prediction market regulation differed from that of sports betting or iGaming, especially with the role the CFTC is playing, serving as a key differentiator?
Well, they're not equipped to regulate sports wagering. The CFTC rulebook, their regulations, and the safety statute has not a single reference to sporting events. None. All that Congress, the only time gaming comes up in the context of the Commodity Exchange Act is a congressional directive to the CFTC to restrict contracts and prevent contracts that involve gaming or activity that's illegal under state law. So Congress's mandate to the CFTC is to reject these kinds of contracts. So what the CFTC is now doing under the Trump administration and under the chairmanship of Mike Selig is not only to look the other way, but to place their proverbial thumb on the scale and try to rewrite the Commodity Exchange Act to allow sports event contracts and to have it under the regulatory supervision of the CFTC. But there's been never any clear congressional authorization specific to sports gambling. And I think that's where the CFTC's and Kalshi's argument will fall apart in the courts, because whether we talk about the major questions doctrine, the presumption against preemption, or the presumption against implied repeals, which are three doctrines that have been raised in all of these federal court cases, the common denominator is that the courts are going to require a clear congressional authorization specific to sports gambling before it will allow the CFTC to oust states of their sports betting regulatory jurisdiction. And that's an argument that highly favors the states and the tribes. And to date, the states have prevailed on 13 out of 15 contested motions for a temporary restraining order or preliminary injunction, which are basically legal remedies that look to the likelihood of success on the merits. So preliminarily, the courts are saying that the states have the better of the two arguments by 13 out of 15, which means that Kalshi has only been successful in less than 20% of their contested legal arguments. So they're losing the battle, but the battle is far from over. Kalshi has very capable, talented legal counsel. All the prediction market exchanges are using, creme de la creme law firms, and the states are in for the battle of their lives here. They're winning, but it's far from over.
And you've kind of also touched on how states reconfigured their approach to prediction markets through striking first in court rather than filing or issuing cease and desist orders. What do you believe led to the change in strategy, and how do you feel it could be more effective in regulating prediction markets?
Well, losing led to the change in strategy. The problem with cease and desist letters is that has always been the reflexive approach taken by state gaming regulators. They did that with fantasy sports DFS 2.0, and they've done that with sweepstakes casinos to some degree of success, where the letters in and of themselves kind of create it's a sufficient motivator to incentivize the actor to leave the state. But it hasn't worked with prediction markets. They had a litigation strategy of using these cease and desist letters to make a federal case out of what is essentially a state law issue. And the cease and desist letters are an imminent threat of future enforcement. And once there's an imminent threat of future enforcement, Kalshi can run to federal court and claim that we're now under siege. If we don't sue in federal court, the state is going to come after us with state court civil enforcement or criminal enforcement proceedings. So the mistake the states made was giving Kalshi the leg up to be able to run to federal court and file the first lawsuit in federal court and make the entire case about the question of jurisdiction and who has the right to regulate sports betting contracts on CFTC exchanges. Do the states have anything to say about it, or is it only the CFTC's bailiwick? And by cleverly filing suit in federal court first, Kalshi and the other prediction market platforms have avoided the question of legality. And the central question in each one of these disputes is whether these sports-related event contracts violate state law. Do they violate the Wire Act? Do they violate the CFTC's own regulation, 40.11A1, which prohibits event contracts relating to gaming? By framing it around the question of jurisdiction, Kalshi has successfully avoided any kind of serious enforcement effort by the states. And that approach began to change with Massachusetts. The Massachusetts Gaming Commission and the Massachusetts Attorney General were the first state government to file a state court civil enforcement action as a first measure. There were no cease and desist letters sent in Massachusetts. Massachusetts went straight for the jugular, filed a suit in Massachusetts Superior Court seeking a preliminary injunction, disgorgement, and restitution. And within the course of several months, Massachusetts went from the filing of a lawsuit to being able to get a preliminary injunction barring Kalshi from operating within Massachusetts. Now, that preliminary injunction ruling is the subject of an appeal, but it showcases the importance of states striking first in state court by bringing either a civil and or a criminal enforcement action. And there is a litigation advantage to doing both. As is presently an issue in the Arizona federal court lawsuit, the pending state court criminal proceedings may have the effect of keeping the federal courts out of the state court enforcement efforts. There's a principle in the law known as the Younger abstention doctrine. It's named after a case named Younger versus Harris in the early 1970s. And the principle of Younger is that federal courts are required to abstain from jurisdiction when there are ongoing state criminal proceedings involving the same subject matter. There's also the other advantage by suing in the state court system, which is the Anti-Injunction Act. And that was raised yesterday or 2 days ago by the Arizona federal judge overseeing the Kalshi versus Arizona Department of Gaming lawsuit. And under the federal Anti-Injunction Act, federal courts are barred from interfering with ongoing state civil or criminal proceedings. So the advantage of the states filing suit in state court first in lieu of a cease and desist letter, which will lead to a federal lawsuit, the advantage of these state filings is that you're going to win 100% of the time if you're the states. You're going to get a quick, accelerated path to a preliminary injunction. And by virtue of the Younger abstention principle and the Anti-Injunction Act, and that hasn't been settled yet in Arizona, but if both those principles apply, it's basically checkmate against Kalshi and other prediction market platforms, at least with respect to those states that sue first in state court and bring a criminal case on top of the civil case or in lieu of the civil case. That's the path to victory, and it's almost bulletproof.
Absolutely. I appreciate you covering all that for us. But stepping away from prediction markets, I was kind of hoping you could take us to what eventually led to establishing your own law firm in 2019. It would have been some of the most memorable experiences for you ever since.
Well, the trigger for that was all the commentary that I did on NCAA versus Christie. My entree into sort of the national gaming space came as a blogger, someone who I was a Florida-based gaming attorney. I was an appellate litigator, a trial court litigator, and I found my calling in tracking the Murphy NCAA case, which was about the whether PASPA violated the 10th Amendment. And I started on that in the fall of 2012, and within a couple of years, I think I gained some traction nationally, and I was certainly the most visible commentator around that space. Well, fast forward ahead, that established my bona fides on the national level, and it basically created the pathway for me to build an entire career around gaming, and it kept me focused on commentaries and legal analysis of important issues that were playing out in the courts involving gambling. So that was sort of my preview, or at least first taste of sports gambling, and I turned that blogging and Florida-based gaming experience into a national practice. So it was basically a case of being the right man at the right time with the right issue when no one else was paying attention to it. And lawyers across the country are constantly trying to carve out a niche for themselves. And I remember being a junior partner and an associate at a large Florida law firm for many years. And the mantra was always find something really good to carve out as your own, to specialize in. And I struggled with that for the better part of close to 20 years. That's how long it took before I found an area of specialization. And my pathway into gaming was fortuitous. It was because of a case I handled on behalf of a Florida harness racetrack that at the time was known as Pompano Beach Racetrack, Isle of Capri. Today it's a Caesars. But at that time, I handled a small litigation for Isle of Capri against Gulfstream Racetrack. And as a wannabe sports attorney, that was the closest I was ever going to get to sports. And that was my pathway into gaming and my pathway into blogging about the Christie versus NCAA case. And it was all so fortuitous. Somebody must have been watching over me. I made my own breaks and I created my own opportunities, but there was it wasn't entirely 100% skill. There's certainly a little bit of luck and fortuitous timing involved with that.
No, absolutely. But that all sounds really fantastic. And, just to wrap up, being here at the IGA trade show and convention, I was wondering how events such as these can provide a deeper understanding of the industry and also help form common ground on the fight against unregulated gaming.
Well, I think it's important to have a meeting place where you congregate and you network and you talk to people that you see online that you're familiar with reputationally, but now they're all in the same forum, exchanging ideas. They're on panels. This is an educational experience, not just a networking experience. So for me, I enjoy public speaking and the opportunity to be on panels where I can sort of showcase my knowledge, but it's probably more important for me to listen rather than just speak. And I take full advantage of that when I attend events like this. And it really helps fortify and cement relationships that it takes a while to build over time. And you can only do it in person, not over social media.
Absolutely. And we appreciate you joining us today. And for the Huddle, I've been Kurt Geller.